We all appreciate your willingness to serve as jurors in this case and take time away from your families and your jobs to be with us and help us see that justice is done. In this case, when you became a juror, you recall standing at the first and you took an oath. And you took an oath to base your verdict solely and exclusively on the law as Judge Burnett's just given you and the evidence as it comes from this witness stand. Not speculation, not conjecture, but on the evidence as it comes from this witness stand. And that's all that anybody can ask you to do. In the judge's instruction also, he mentions sympathy. Well, ladies and gentlemen, this is not a case about sympathy for either side, and it's natural for you to feel sympathy. But in this case, we don't want you to feel sympathy for anybody in the case. We don't want you to allow that to affect your decision in this case. We submit to you, after you've looked objectively at the evidence in this case, at the testimony in this case, that you will return an appropriate verdict of guilty to 3 counts of capital murder. Now, in this case, Judge Burnett has instructed you that in order to sustain a conviction of capital murder, in order for you to return a verdict of guilty of capital murder, the state has to prove 2 things beyond a reasonable doubt on each count. That is, that with the premeditated and deliberated purpose of causing the death of another person, this defendant or an accomplice caused the death of Michael Moore on count 1, Stevie Branch on count 2, and Chris Byers on count 3. Now, in regard to the reference to an accomplice, the judge has given you an instruction on accomplice. And in this instruction, he tells you that a person is criminally responsible for the conduct of another person when he is an accomplice. He's just as guilty if he's an accomplice. And an accomplice is one who either directly participates in the commission of an offense, or who, with the purpose of promoting or facilitating the commission of the offense, he aids, agrees to aid, or attempts to aid the other person in planning or committing the offense. Now, the definition of purpose is on here too, and these definitions are real important. And if you look at it, you'll see that a person acts with purpose with respect to his conduct or a result thereof when it is his conscious object to engage in conduct of that nature or to cause such a result. I'll lose my voice. Now, what I would like to do now is take the elements of the offense and go through with you the element that we have to prove and what the evidence has been in this case. First, that with the premeditated and deliberated purpose of causing the death of Michael Moore, Stevie Branch, and Chris Byers, this defendant in his this defendant in the statement before he admitted being present, he tells Detective Ridge and Inspector Gitchell that he has a phone call the day before the murders and that he's told that Damien and Jason are going to West Memphis and they're going to get these boys and hurt them. He also testifies that at one of these cult meetings he mentions that a photograph of not just some boys but these boys is passed around at this meeting. Now, Miss Byers testified about her son coming in a month or so before and saying about how some strange man, all in black, had taken her picture, taken the son's picture, Chris's picture. He also stated that Damien had been watching these boys. He had been stalking these boys. Premeditation. In looking at premeditation, the injuries themselves speak loudest. Multiple skull fractures. Chris Byers bleeds to death, and Stevie Branch and Michael Moore are drowned. Was the Was there a conscious object to cause death? Unquestionably. I don't believe anybody could dispute that. The second element is that the defendant or an accomplice caused the death of Michael Moore, Stevie Branch, and Chris Byers. The defendant himself, in this taped interview, describes this event. He describes his participation, or what he says is his participation in this event. The defendant's own expert says that the natural inclination of a defendant is to lessen his involvement in the offense. And I'll come back to that a little bit later. So he describes it for you himself. In the way he describes it, it reveals a premeditated and deliberate murder, although he tries to lessen his own involvement. Now, these alibis, being in Highland Park and wrestling, this was a parade of the defendant's friends. You saw the yellow ribbon. The judge tells you in judging credibility, you judge demeanor, the way the witness testifies, whether there's, and I'm not giving this word for word, so rely on what the instruction says, not what I say it is. Whether there's any reason not to be telling the truth, any bias, anything to be gained from the outcome of the case. And when you look at the people with the yellow ribbon, the bias is obvious. They're here to try to help the defendant. Now, when you analyze their testimony, and this isn't a real impressive professional little diagram I've got here, but when you analyze their testimony in regard to Highland Park, and of course you can't see this, but I'm still going to refer to it because it helps my memory. The testimony about where the defendant was up until about 5:30 is really pretty consistent. It's pretty consistent among the witnesses. But when you get to the crucial time around 5:30 or 6 o'clock, these witnesses have this defendant in 3 or 4 different places at the same time. You look at it at about, Susie Brewer. She's got at around 6 o'clock, between 5:30 and about 7, she's got her and the defendant on the street together and at Stephanie Dollar's house. If you move down to Jennifer Roberts, she's got at 6 o'clock the defendant and Christy Jones on the defendant's porch. Christy Jones says that from beginning about 5:30 or 6, she and the defendant are on her porch by themselves and for about an hour and a half. So anywhere from 5:30 to 7 or 6 to 7:30, she's saying that they're sitting on the porch all by themselves. If you go down to Mr. Hoggard, he puts at 6:30 Jessie by himself out in front of Stephanie Dollar's house. Not on the porch at the defendant's and not with Susie Brewer down the street. Mr. McNeese says that about that time that he sees the defendant at this police car, which is down the street from the defendant's house. And finally, Jessie Sr. says that he sees the police are there when he gets home from DWI school. Well, the DWI school doesn't leave in until almost 8 o'clock, and if you look at this radio log, you'll see that the officers checked off the scene there right before 7 o'clock. Or 8 o'clock. Anyway, it was at a time when they had already left by the time MISSKELLEY Sr. got home, or even left where he was. So this is all totally inconsistent. And then when you go to the wrestling alibi, that was a total mess. You have Fred Revelle, the only person who comes to the police and says, look, I think y'all may have made a mistake. He was with me, and here's why he was with me. We had gone wrestling. It was me and Jessie and one other person, I believe he said, and in his first statement to the police. And I know it was that day because that's the day we paid the money. So the police, naturally, doing their job,
they go out and investigate to see if he's right. That was the defendant somewhere else. And lo and behold, what do they find out? The money was paid a week before that. And they get a receipt to prove that. Well, then when Mr. Ravel comes into court and testifies, the story is completely different. And he hadn't told anybody about it with law enforcement. Then you have Dennis Carter come in here and say, yeah, I went with him May the 5th. I know it was May the 5th. Sure as I'm sitting here. I said that, he didn't. But that's the gist of his words. And then what did he tell the police? Shortly after, keep in mind, this is when it's still fresh in their memory, shortly after the arrest of the defendant. What did he tell them? He said, I didn't go wrestling then. I didn't go wrestling until after the murders had happened. Days after. Just a mess. And then finally, after witness gives these confusing and conflicting stories about being wrestling or not wrestling, you have this Johnny Hamilton come in. And he testifies that, well, I'm sure it was that day. Kevin Johnson was at search and rescue. Keith Johnson went, and that was the only time he went. Keith Johnson says, yeah, I went wrestling one time, and some specific events happened, but I don't know when it was. Keith Johnson, I think, told the truth. He didn't have any idea when it was, but yeah, he'd been wrestling with him one time. How do we know that's not true? Not about Keith Johnson, but about that it was May the 5th. When they went wrestling, they signed this document. Keith Merciers, I hope I say that right, he came in today and testified, I only went one time. I went one time, signed the form, and it was before the murders. He's the last person that signed. He had to have signed after Keith Johnson, after Johnny Hamilton. Keith Johnson only went one time. So Keith Johnson had to have gone before the murders for Keith Mercier to have signed after him. Also on Mr. Hamilton, he says, well, I'm not going to drive 600 miles for nothing. He will drive 600 miles to testify, but he won't go 3 or 4 miles from Highland Park to the police department to tell them, hey, I think you made a mistake. He didn't tell anybody. He didn't even tell the defense. He didn't tell anybody. Somebody goes and talks to him last Sunday, and he says, oh, yeah, I remember vividly. May the 5th. Where were we May the 5th? I ain't got the clue. The defense then moves from alibi to Mr. Bojangles. Remember Mr. Bojangles? Remember that? Is there any evidence to suggest Mr. Bojangles had anything to do with this? You have a sheet with a single negroid hair fragment. A single one. And so they pick out Mr. Bojangles to present up here as, must be the person who did it. Well, let's think about that a minute. Well, there's blood. He came in, he was kind of incoherent. Is there something to that? Could it have been Mr. Bojangles? Well, let's think about it. What about the crime scene? Picture in your mind the crime scene, and then picture in your mind Bojangles. The crime scene, not a drop of blood. Not one. Couldn't find one. The bodies were hidden. The kids' clothes were hidden. They were crammed down in the mud. The blood was washed off the bike. Had the scuff marks. Contrast that with Bojangles. Goes in there and he leaves blood all over the place. Down the hall, on the wall, on the floor, on the commode, all over the place. Do you really believe that a guy is going to go to the trouble of cleaning up the crime scene, hiding the kids' bodies, hiding their clothes, hiding any evidence of this crime that's taken place there, and then he's going to walk down through a field to Bojangles Restaurant, a public place, and leave blood all over the place. Give me a break. The defense in their opening claimed that there was going to be proof that this was Damien tunnel vision. There's no evidence of that. None. The testimony was that yes, Damien was a suspect, but he was one of a number of suspects. Just one of a number. Let's talk about these experts that were called by the defense. As the judge has instructed you, because somebody is labeled an expert, and that applies both to the experts testify on behalf of the state and experts testify on behalf of the defense, you're entitled to weigh their credibility, judge what you hear from them, and decide whether you think it's of any value or not. Let's start with Mr. Holmes. What makes Mr. Holmes an expert? He said why he had 13 years of law enforcement experience. He'd worked for Miami Police Department for 13 years, and since that time he's been a lecturer and a witness. Inspector Gitzel's had 19 years of experience. Now, but let's talk about it. Actually, you think about it. Now, Mr. Holmes is a good witness as far as presentation. But when you sit back and really think about it and analyze what he said the police didn't do anything wrong. He had some problems with the content of some of the questions and some of the responses. But as far as the police being coercive, he said the police didn't do anything wrong. In fact, if you'll think back and use your own memory, but do you remember Mr. Holmes saying, I would have done the same things myself? You remember that? Mr. Holmes' complaint is time and literature, the not. And in his testimony, he says he complains because they didn't clear these things up. Well, as the testimony's been, and Mr. Holmes himself admitted, when you're interviewing somebody, you don't stop all of a sudden and start cross-examining them about something they said that may be wrong. The goal is to keep the person talking. And then he says in his testimony, well, they did go back later and clear up the time, but not the literature. And actually, when he said that, if you will look and listen to these tapes, there's nothing said about how or what they're tied with until the second statement anyway. So they didn't clear it up after the first one because it wasn't in there. It was in the second one, and that was not cleared up. Now, I want to go through some of the things that Mr. Holmes said that you looked at in determining whether you've got a coerced confession or good confession. I think that's the way he put it. He says on the problems with time and the ligature, he gave a few possible explanations. You know, he had to have been doped up, or he had to have a faulty memory, or maybe just he wasn't telling the truth. Now, what do we have in this case? You know, the evidence doesn't show whether Mr. Holmes was familiar with Dr. Wilkins' examination or not. But what do we have? We've got a defendant who huffed gas, smoked pot, abused alcohol, and he found significant memory deficits. The very things that the defense's own expert said could account for these problems. He also said the most important thing, and I wrote this down, that the person sounds and looks like they're telling the truth. Yet, Mr. Holmes admitted that he had formulated his opinion before he even heard the tape of the defendant. He'd had a transcript. But how do you judge how they sound if you don't hear the tape? And he had already formulated his opinion. He gave a number of factors. It's an indication of relief. It's finally out. There's some indication of relief. Well, what was the testimony? The testimony was that after the defendant, or about the time the defendant finally admitted that he was there when these crimes occurred, that he cried. Is that not an indication of relief? Like, whew, it's over. He also says, as one of the factors, if you are wrong in a supposition in questioning the person, he will correct you. Well, let's see if you find any of that. The factors the defense's own expert says to look for. If you're wrong in a supposition, he will correct you. On page 3 of the transcript, Inspector Ditchell asked, whose car were y'all in? Suggestible question, isn't it? Leading question, isn't it? Well, does he buy in? Does the defendant buy into the suggestion? Does he go along with the supposition? No. He says, we walked. He corrects him. No, we didn't go in a car. We walked. Then, on page 10 of the transcript, if you're wrong in a supposition, he will correct you. Detective Ridge says, did they take like one picture of one boy? The supposition is there's one picture of one boy. Did he go along and agree with this supposition? It's a suggestible leading question, right? No. He says they were in a group. He corrects them. No, it was not one boy in one picture. The boys were in a group. Then on page 18